Did it again, didn't I? I'm not used to my new system here, and I forgot to bring us into the mix. Hi, and I'm also
Hey, I haven't seen you for a
out.
while.
I know, outrage of the moment.
Outrage is the moment is right for a lot of attorneys that are watching this, and I think where is justice? Well,
Well,
today,
at the moment, it
nowhere.
ain't in Canton. I'll tell you that. Should we?
Right.
I mean,
Why don't we
I
tell people what's happened since we last? There you go.
Oh, look at that. We're in circles. That's new, I think. I don't think we've been in circles before. Oh, look at that. We're in circles. Oh, I think that's an option we never used before. So here's the deal. We heard this morning that crazy hearing, of course, in front of Judge. Go ahead. Can you say that?
His name is
Sissiski? Bless you. Bless you. Adam
I'm sorry,
Adam
Judge Adam
Sissiski.
L.
Yeah.
Siski. It's
Uh,
Siski.
yeah,
Oh my
forget.
God, I'm having trouble pronouncing
It's Adam
Siski.
S. to me. Okay,
Yeah,
so he's
Siski,
sitting in to
right.
hear the Rule 17 motion, which is a motion brought by the Hank Brennan prosecution team to get Aiden Carney's phones, not to get the phones because they've had those, but to get the guts inside them because they believe there's some proof of consciousness of guilt between Karen Reed and Turtle Boy to intimidate witnesses, somehow muck up the process. So they want to see inside those phones. So we hear that argument. We hear the defense. Attorney Bradel, I think, put on a fine defense of that. And then we just get the order.
Yeah, and I have my notes because when I was watching it, the judge asked some good questions. Well, what's really bothering me is this and that, and you're thinking, well, this sounds pretty fair. Like he's going to be pretty fair.
That's what you would think, right? However, let's go. Let's go to just. And I'm not. I'm taking direction from some of our viewers who said, "Quit scrolling through these things so fast. If you're not going to read them, then just at least freeze on them for a moment." So I'm going to go very slowly until we get to the part that we're going to read. This is the decision, memorandum of decision and order on Commonwealth's motion for records from dockets, and you notice it has both docket numbers on there. Clever, because for those who missed that this morning, Judge S was kind of ragging on Alan Jackson and Ms. Little and Karen Reed, and I think Yannetti was there too. I think the whole team was there.
Yeah, the whole team walked in.
They all burst in while they're in the middle of Hank Brennan's argument. Well, first of all, Hank Brennan should be ashamed of himself for just launching into this, not even telling the court, we might want to wait a second because I believe defense counsel for the Karen Reed matter, they may be here. Of course, Attorney Bradel was there for Aiden. But anyway, he's a bit of a slime ball.
Yeah. But when you said that they came in and so what do you say? Yeah, this is their docket number, but apparently there was a belief at that moment from the judge that it didn't matter whether they were there, and Hank Brennan certainly wasn't going to care whether they were there, right? One less group of people to have to deal with.
Yeah, I know. I just think that's cheesy, just to launch into it, knowing you just had a scheduling conference with the judge a day and a half earlier, which included the anticipation of this hearing going forward. It's just what's he think he's going to get away with? I'm going to sneak this in.
Yeah, let me tell you today. I have to tell you, after everything that I watched today, Michael Bryant, I've been pretty fair on one side or another, even though I had a bent as to because I think things were done pretty sloppy. But today, if I were on either team, I'd be pretty depressed about whether or not there is fairness and justice there.
Yeah, no, I agree. It just seems like at every turn, things are just shaky. And as I said earlier today, I said, I was waffling between intentional conduct and just horrible at their jobs. And it just keeps pushing me toward intentional conduct, or misconduct. Okay, so you get down to the bottom, just to touch on this before we get to the basics. For these reasons, the Commonwealth motion is allowed in part. Now, you might be thinking, what would that part be? Because remember, it was a pretty broad net that was being cast. And Attorney Bradel was saying, look, we're going to have issues of, marital privilege, of journalistic privilege, of attorney-client privilege. All these things need to be figured out before you just cough up what's inside these phones. I mean, they're going all over the place.
And the tank team apparently never really got the phones for those purposes. It
Yeah,
was a workaround. The
that
tank.
taint right. And so as I scroll through this slowly, not to give anybody whiplash, we're going to get to the what I believe are the most important parts, which we can talk about. Okay. Um, Key ingredient for the Commonwealth argument is that, hey, we can't get this stuff anywhere else. How are we going to get this stuff, right? So they cite the law, the Lamprun case, the Dwyer case, all very important. And then we get to the guts. Here we go. At the hearing before the court on March 20, which was all of today, the Commonwealth orally significantly narrowed the scope of its request for data called for in its motion such that now before the court is only the Commonwealth's request for the following data extracted from the two phones in question. Now, before we get to that, an important footnote, right?
Right. A very important footnote.
There we
One
go.
that I
And
picked
this
up.
is something you pointed out twice as we talked about it earlier today. The Commonwealth has suggested that it may not even be required to seek the order it currently requests from the court in order to obtain the records at issue, given that the data it seeks is currently in the Commonwealth's possession, albeit in separate criminal cases overseen by another special assistant district attorney, Karen Reed case. The court declines to address the validity of this suggestion at this time and addresses only the Commonwealth's argument in support of its Rule 17 motion. Well, I don't know. I guess it's convenient to ignore that, right?
Pretty convenient. Here it is. Here's my notes. Here's where I actually run the bottom with a big yellow asterisk. Hank Brennan says he will get them if the court
No matter
decides
what. And
not,
he's
no
basically
matter
saying,
what.
I already got them. So I'm being here because I'm a nice guy. Is that what he's suggesting?
So has there been discussions between Mr. Cosgrove and Mr. Brennan and the attorney's office about what's in the phones anyhow? Have those discussions existed without actually turning over the documents, or have they looked at the documents without actually taking physical possession on the one side? This wall there is no wall, basically, is
I'm
what
sure
that
it'll all
says.
be expressed very clearly in this order. So as we move through page 4, this is the follow-up on where it says the following data. This is now the narrowly tailored part of the request. Number 1, communication between Aidan Carney and any witness or family member of a witness involved in the murder of John O'Keefe. I like the way that's written. It makes it sound like the witnesses were involved in the murder of John O'Keefe.
Right,
Maybe,
right. But it also says that there's a murder of John O'Keefe.
I know.
Okay, that's the interesting thing, and he says that not just once. He says it at least 2
I
times.
know.
Yeah, and that
So
hasn't been decided.
he's not only finding Karen Reed guilty, because that's the case pending against her, but he's also indicting in his way all these other folks that have been talked about as potential third-party culprits. So Jennifer McCabe, Matthew McCabe, Brian Albert, Christopher Albert, all the normal suspects, literally, Colin Albert, Juliana Albert, Michael Proctor, and Elizabeth Proctor from, here's the period of time. My guess was 7 months when we talked about it earlier. It looks more like 6 months. April 8th of 23 to October 5th of 23. Okay, so that's the window now that's been narrowly tailored. Part 2, pictures or videos depicting evidence of intimidation of a witness, of any witness or family member of a witness involved in what?
The
The murder of
murder.
John O'Keefe, to include but not limited to Matthew McCabe, et cetera, all of the same folks. Now, this is going to be determined by whom? Who's going to decide what is or isn't evidence of intimidation of a witness?
Mr.
Of
Cosgrove,
course, Mr. Cosgrove.
the special prosecutor in Aidan
God,
Carney's
talk
case.
about home court. Okay, number 3, data evidencing insemination of data depicting evidence of intimidation. Okay, let me think this through again. Data evidencing dissemination. Okay, so if something is forwarded to somebody else, I suppose, I guess beyond the 2 that are the focus of a given communication, of any witness, family member, witness involved in the murder, the what? The murder of John
Murder. Here we
O'Keefe,
go again.
and includes all of those same folks. So the narrowing seems to be to the time frame and to the people, but in terms of the subject, it's still wide open.
without any mention of journalistic privilege, without any mention of
Or
husband
who's going
wife
to be the
privilege,
gatekeeper?
or who's going to be the gatekeeper. Let me just tell you before you go, let's do a couple comments from our viewers who are here
I'm sure they're
watching.
not
Olivia,
happy.
no, hey, Olivia, now, hey, Linda and Michael, today was a dark day for justice.
Brutal. And we're going to have Olivia on, right, at
Brutal.
some point. Is that right? We're going to try
Well,
and do
Olivia
that?
Camp is going to be on some
Yeah.
point. Yes, Olivia Camp is going to be at some point. And then Scott McGinnis, Scott
Hey, Scotty.
hey Scott, if you're watching, hi. We certainly love to have you. You after we talk, have your, just to give Missy a shout out. Meatball Morrissey wants Turtle Boys reporting sources, info on the federal investigation. Okay. Yeah, info on the federal investigation. Ray Olivia, we're working on next week. Yes. Isn't that interesting? Because now, interesting, the Department of Justice, as we know, is kind of in like a, it's all being revamped and redone because of the new president of the United States. We know that. So we don't even know if the people that were on this are still there or even care when they're thinking about their jobs right at this point, right? I don't know, Michael. My reaction. This happened after we went off the air. We got it right.
Yeah, it's not. It's fresh off the press. The ink is still
My
wet.
reaction is where's the taint team? Where's the third
Yeah,
party?
there's just zero reference to that. The court has made Cosgrove the taint team, the independent third party in camera reviewer of this material. It's the fox guarding the hen house. It's
and
ridiculous.
and let's remind everybody that just was it yesterday or was no, Wednesday? Were you there? Wednesday when you went to the hearing. Was it Wednesday or Tuesday?
Tuesday,
When you
Wednesday they
went
were
to the
off. Yeah.
hearing, then they were Cosgrove is the attorney who previously I thought, okay, he's trying, because he was expressing some, closeness with regard to the charges, but then he's the one who wanted to have Aidan Carney's bail revoked on 5-minute notice to Bradle after telling him he wasn't seeking any of that. This was just going to be a plain old arraignment that happened. Now, it seems to me that the only gatekeeper of justice may be in that court in Stoughton, because it certainly ain't here.
Yep, and I can I could just hear the reaction and the plan from the defense team, clattering away, working on something because they can't let this lie.
No,
There's no way.
no.
Okay, let's finish off what the court had to say here. Okay, so again, highlighting the Commonwealth arguing that the requested data is relevant and, of course, relates to quote consciousness of guilt evidence end quote. That's what we've at least known that from the beginning. Commonwealth's request, as presented, would scoop up an entire universe of Mr. Carney's own messages, photos, videos, and communications with others, with no regard for or limitation based on whether the defendant knew or was involved in such communications. As to that type of data, the court finds the Commonwealth has not met its burden. Now, this comes after we've seen what the court has found to be the narrowly tailored amount.
Right.
How is that any different? How is that
Right.
broader than what's being allowed, except in the date time frame?
Yeah, the daytime frame seems to be the only thing that, because the witnesses, that's clearly the witnesses they were talking about from the beginning. And that's
Course.
why those are the ones
I mean, maybe you
on
and
the
I were
witness
in the
list.
original request, and now we're not. I mean, it's just those were the targeted people.
Yeah, but let's let's take this one step further. This could be anybody. This could be you or I. This could be any blogger. This could be any streaming channel that's commenting on this, that comments against the Commonwealth here, whether they've done anything wrong, right? Because they could, if we say, oh, that wasn't witness intimidation, that D&E pizza, that new charge. Well, maybe they're saying that because we're saying it's not witness intimidation, we're intimidating the witnesses, right? Because we're, quote, coming after them on social media. Therefore, is all of our stuff open to the Commonwealth? That's really where this is going. I mean, I think the media has to get involved. I think the
I would
mainstream
not be
media has to
surprised
get
to see
involved.
some media representatives, bring some sort of intervener type motion or something. I don't know what they call it there in Massachusetts, where third parties asked to intervene and
But don't you
be
think they already had
understood.
the records? And as soon as this was filed, when was this actually filed? What was the time frame that this was filed? That we have it, the exact time that this was
That I
filed.
don't know,
Hold on, let me see
because I
when.
know the court said it was on calendar for X number of weeks, so it's been a
Uh,
while.
so let's
I
see.
just want to mention Erica Sandwall says in all caps, so she's yelling at us, Karen Reed is guilty, and so is Turtle Boy. So,
Well,
um,
if you think that, let the
but
Commonwealth prove it in court. We have no
of course,
problem if the Commonwealth proves that in court. If they prove it in court, absolutely. We told you we accept all viewpoints here on
yep,
this, but they have to prove it beyond a reasonable doubt. What I'm concerned about is you and I know we got this order and we had it distributed to us about 4:57. It was filed at 2:22. Olivia Nile says, and we're working on next week for Olivia Campbell to come on. That 2:22. You know that I think at 2:23, this stuff went shoop. They weren't waiting for an appeal. They weren't going to wait for someone to come in and say stop. Order show calls to stop. This stuff is already over there. It's
yeah,
there.
yep. I can't wait to see them maneuver. And I did see some other channels for the first time, people talking about the continuance, which we began talking about last night and talked about again today when it was denied, as we predicted it would be. But all these things keep piling up, making it, if not prejudicial, it certainly affects the defendant's ability to put on a case when you're being crammed into such a hard and fast start date. Not to mention, can you make your arguments in 2 minutes? Go. Jimmy, stand up when their 2 minutes is up. If you guys missed that earlier today, at some point, Judge Bev decided this was going to be a lightning round. It was like speed dating for motions. You only got 2 minutes. Make your pitch.
Yeah, it
And
was that. So we have a couple people more who believe that both are guilty. But if that's, the jury didn't find Karen Reed guilty. Let's remember that, because the burden of proof beyond a reasonable doubt in all these cases is on the government. It is on the state. And that's what we are speaking about.
of
We're
course,
also speaking about the First Amendment, which seems to be in the news for everybody. Everyone wants the First Amendment. Until the First Amendment seems to go against, a person or somebody who's on trial that you don't like, then all of a sudden no one wants the First Amendment. Okay, that's how I feel about it. If there's a First Amendment, there's a First Amendment. Now, if there's witness intimidation, what real witness intimidation is? We see it,
yeah,
gun to head. I'm going to
exactly.
kill your mother. I'm
I
going to kill your
take,
mother unless you go testify this way.
I've
That's
taken
witness intimidation.
all of Turtle Boy's charges, and I've looked at them and I've said, okay, how do I get to that level of intimidation? And the one most recent is the one I can think of off the top of my head, where he is first staring into the camera there at D&E Pizza, right? And then he's going off with a rant. I'm setting aside the potential wiretap issues for the moment. But if something is said, or even when he's just looking at the camera, if he takes his hand and he's like this, and he's like, threatening in a way that suggests, one of those, I'm going to do this, I'm going to do. I mean, now you're getting close, at least, right?
Yeah, but even I did it way,
Oh wait,
talking
quit
about
threatening
some
me!
argument,
Stop
right?
threatening me,
Yeah,
Linda.
it's not medicine threatening you.
I'm just giving an example of what It's a sliding scale. You got to see something, and at
Right.
least that gets you closer, if not to the point where you would find it criminal, but it's something. And then if it's a phone call, if it's a sign, I'm going to kill your kids if you don't testify the way you should. I mean, something,
Right.
not
Like we
just
see in the
tell
movies.
the truth. Remember, that's the basis of one
Yeah.
of the charges: yelling at
One of the
witnesses to tell the
charges is,
truth.
one of the charges is yelling at witnesses to tell the truth. Okay. Now, what is the last thing any lawyer ever says to their client before they go on the stand?
Just tell the
Tell
truth.
the truth.
And I tell that to every witness. I wouldn't say just
Every
my
witness.
client, every
Just not
single
every,
witness.
just tell the truth, whatever it is.
Once you've interviewed them, once you've gone over whatever, what they're going to testify about, not coaching them, but just listening to them about it. All I want you to do when you get up there is tell the truth. And
Right.
all you're hoping, you hope that the opposing counsel ask that question of the witness. Did you have a conversation with Mr. Bryant? Well, yeah, we talked before. What did he tell you? Well, he told me to tell the truth. Winner.
Winner. I've had that happen. That
Of
people, oh,
course, it
what is your
happens all the time.
conversation all the time? And of course, and the last thing, of course, that's what you tell people if you're, especially if you're a defense attorney, because they're looking. They're looking. What did you tell them? Look, just tell the truth. Whatever it is, tell it.
Yeah, simple. Mary Romine, is the timer thing legal? Well, I guess at a certain point it becomes prejudicial to not let one side or the other present an argument on the record. The real question is, where is that? At what point? She did back off when she was told. I think Yannetti was the first to say, "Look, I can't do
Right.
this in 2 minutes."
Right. I think it was 4 minutes. He says, I can't present this in 4 minutes.
So it's going to be a touchy-feely situation, but 2 minutes to me, what self-respecting attorney can make any argument in 2 minutes? Come on, there's a reason we're paid by the hour. It's
sometimes
nothing happens in 2 minutes.
Yeah, sometimes you'll go, you'll have an appellate argument for a court, and there's briefs filed, they've read them all, and you will get up there and you'll say to the court, Your Honor, I filed all my paperwork on this, my briefs are filed. Do you have any questions beyond that? I'll be happy to answer them, because you don't want to waste your time, and they're well versed. And then they'll start asking you questions, but you've given them the option to do it. Here it was like, okay, I invite discussion, but only for 30 seconds. I can name that too.
I know. Okay. Can I just say one thing? Okay, 30 seconds. Two sentences. No, and on the appellate grounds, it's very different, because you really have to rely on your papers. Whatever's been submitted. If you start straying into repeating what you've presented in your motion or your appellate brief, they're going to come down on you. They're going to say, "We've read this. We don't need to hear this. What do you got new? What's different?" And yet they still get more than 2 minutes.
Yeah. And when you argue in federal court, for those who have and for those who aren't familiar with it, there's lights. There's a red light, there's a yellow light, and there's a green light, because you have a certain amount of time. You may have 20 minutes to argue, of which you can have 15 in the beginning, 5 you save. And when the green light means go, because your timer is starting. The yellow light will mean you have like a minute left,
Just
usually.
a warning. And the appellate's very similar. Yeah.
And then when the red light is, you could be in the middle of a sentence and you stop, but you have that whole 20 minutes to work with one way or another. And sometimes the court will say, "Oh, Ms. Kenny, but we'd like you to finish this. We'd like you to talk more. Don't worry about the thing." They'll do that because they're interested in the argument you just made. But to say, "Okay, you have 1 minute, go." Oh, okay.
Yeah, and it seemed to come after a break, as I recall, where she was, somehow she was calculating how much time it was going to take to do the remaining motions, and she was already suggesting we're going to have to spill into tomorrow, which now has become next week. Well, too bad,
Well, that's because she set the April 1st deadline.
I know, and it's
and all this has been truncated. And in fairness to both of these, for all these attorneys, to both sides, they're gosh darn tired already. They're exhausted. They have been in court almost every day, I think, for the last 30 days. I mean, it seems to us that we're covering this case. Or they're having to file papers. They're having to file motions. They're having to get prepared, especially for the attorneys that have to travel, maybe to California or from New York or whatever. You can even it doesn't matter if you've rented a house, whatever. You're trying to get ready for trial. You have an opening to do. You have witnesses to present. You have orders. You have to decide who's going to do it.
They hadn't even gotten the questionnaires prepared, which that was asked for 2 days ago. And Tracy Hernandez is wondering, doesn't Auntie Bev have any judge friends who can say, "Hey, your bias is so apparent, you may as well just sit with Brennan"? I think she probably does have judge friends, but either she's not getting any advice or she's getting bad advice.
Well, I think what happened is, and I'm going to say it again, you saw a marked change in how she treated the defense when she felt that she had been lied to in terms of the turning over of the Rule 14 after the trial ended, and the payment issue. And then she felt that perhaps the defense had said that the ARCA people were not were totally independent, causing what she believed to be a fraud upon the court. Okay. And you saw that specific change right there. Now, Samuel Stanley has a question. If you are Hank Brennan, how do you run the prosecution if you would like to win without dropping
Oh,
charges from a tactical setup of the case.
mm.
Michael, I'm throwing that to
Yeah,
you.
I wish Samuel had not said without dropping charges, because that's the first thing I do is drop the top charge of second-degree murder. It's a joke and it's an overreach and it's an embarrassment, and it makes you wonder about the other charges. But assuming you've got to stay with those, doesn't mean when you present the case you have to go overboard on that, right? Especially if you don't have the goods. What goods do you have that she intentionally killed him? I mean, that's a dead bang loser. So I would focus on what you do have. She was driving under the influence. That's going to be pretty well established. And let the jury figure out if he didn't get on the ground by her hitting him with the car, whether intentional, negligently, or otherwise, how did he get there? How did that happen? How could it possibly have happened other than her actions? Because that's the whole case. That's all you got. I'm not
Right.
saying the evidence is great, but I think you got to pound on that.
But you heard today with that motion about the fighting or whatever, the motive. He told her the night before that he didn't want to be with her. That prosecution is going to go there. They're going to say she was so angry at him because he wanted to break up with her, as opposed to she wanted to break up with him. Type bit. But
and they did that in the first trial. We saw it.
In the first trial, and maybe the answer is you want to break up with him because she was taking care of the kids and she didn't want to leave those kids alone. I mean, I think I'm the defense if you deal with that more. But that's where you are now. Robert Shank also has a question for you, Michael. A question: did your head spin, and how fast Judge Cannoni ruled on speaking objections?
This is one of my personal peeves, and we've talked about it before. I just don't get it. She's so indignant about, breaking what she believes is the way we do it in Massachusetts. It's the way we do it here. So it's a stupid, dumb way to do it for the people involved in the current trial. It's worse when it goes on appeal if there's a conviction. But we do it that way, doggone it. So we're going to keep doing it that way. You get your neck bowed. That's what we used to say.
Can I say something that's insane? I told you that this year she was on the third week of the Harvard Trial Advocacy Workshop. I never met her. I'm on the first week. We teach the young students, the second and third year law students, the basics. They're trying to get the basics. How do you present a witness? How do you do direct? Is the first thing. How do you do cross? Right. How do you openings? Right. We don't get the closings. And the other thing is objections. That's how what do you do objections, and that's concentrated on more on the second week. But it's always one word. Have and tell them have a list next to you of what the basic objections are: hearsay, irrelevant, speculative. And now you really have to have it with most courts with the rule, because sometimes courts don't let you even say that.
Like the feds
they
do,
let you say the federal courts require you to say the rule, not the actual objection. It's usually what it is. All right, but and then you have it so that you could always say in one word, objection, hearsay.
I'll take that. I mean, I don't want to get greedy and ask for the rule as well. The rule, the statutory code section. Just give me the word. I always remember I was doing a trial as a second chair because I was with a partner, and in your first trial, that objection it's like scary. It's like a driver's test.
Totally scary. Excuse me as I choke to death here.
and so I'm getting the elbow, and he says irrelevant, immaterial, lacks foundation. Those three things. And so that's my objection. Objection, Your Honor. Irrelevant, lacks foundation, immaterial. And the judge says, "Oh, the typical Perry Mason objection."
Oh, that's great.
So that was the last time that I succumbed to his elbowing me, and I was fine after that.
That's a great story. We have another question from Nancy. Can someone explain why a new judge was having an open court ex parte this morning? What was Brennan trying to do? It was giving. I think it was giving
Glanville.
Yeah, it was giving like a Glanville. Somebody also said that you thought that Miss Love and YSL, remember, because Glanville and Love were YSL were bad. Well, you haven't seen nothing yet.
Yeah, exactly. She would be an interesting calming influence, wouldn't she?
I don't know about that, but she'd be the 1 minute argument. That wasn't what
Oh my
fly with
God.
Ms.
Take,
Love. That was,
takes her that long to, straighten her notes. Let me finish looking at this document so we can get rid of it and see more of us and less paperwork. Um, so here's the what's being allowed. The court has synthesized it into these 3 paragraphs here, but it's all everything they've asked for, from what I can tell, except for a narrowed time frame of April 8, 2023 to October 5, 2023. And then I'm continuing to scroll. I'm looking for who it's going to pass through. How's this? Who's the gatekeeper on this? Who's the decider? And here it is, the best you got.
do you
Specifically, Special Assistant District Attorney Robert Cosgrove to produce from the 2 previously identified cell phones that were obtained through search warrants in connection with the 2 criminal cases, blah, blah, blah. That's it. He has carte blanche to do whatever he wants, apparently.
Do you think that where does this opinion start? On what page that it starts actually getting to what happened this morning?
Oh, let's
Because what
see
let's
if it
see.
was split. Don't mind me scrolling here, folks. I'm going to try and get back to the top, because first there's the factual setup, and then there's the law, and then there's the decision. Here's the discussion. So I would call this the decision if you're looking for a specific point. That's page 2. So page 1 is really just the setup.
Yeah, and discussion. So because that's a lot of writing to do between the time of when did we
Oh, so
finish
you
the
think this
hearing
was
this morning?
pre-done?
That's what
That's
I'm
what you think.
suggesting. That's I'm suggesting, as opposed to what you need when you get to the point where the Commonwealth limited their argument this morning, and of course my footnote that it's in a footnote. All of that could have been pre-done, and then where the Commonwealth limited their, maybe there was a denial until there was a limitation, on that, and it could have said something that I'm not giving this, but I'm going to give this. You
Right,
know, it
right.
could have said something like that. I find that it was overbroad. However, I find that within the request for the argument, the Commonwealth is entitled to this without the, and you didn't even need the line there then, which say the Commonwealth significantly limited what they were looking for,
Which doesn't
today.
help you a lot when that's not really laid out. It's not like, here's A, what they asked for, here's B, what they're getting.
Right.
That would have been very nice, very clear, very clean. To Nancy's question, yeah, you're right. It did begin to look like ex parte, but remember that Aidan Carney's attorney, Mr. Bradel, was there. So the question is, why wasn't the Karen Reed team allowed, notified, waited for? That part seemed to be inappropriate when they had all talked about it just a day and a half earlier. So
Right.
not
And
technically ex
when,
parte, but a little
yeah.
weird.
And when the judge almost castigated them. Mr. Jackson,
Yes,
and this is in
it was
front of the
almost like, get the
cameras.
hell out.
Yeah,
Get the hell out of here.
well, where's your opposing brief? And he said, well, we told Judge Canoni we were going to be arguing orally against this. Where's your? And he said, the case has nothing to do with you. And Alan Jackson said, it's our docket number. It's Karen Reed's docket number
And
on
that
here.
was when I say the oh shit bubble popped on top of his head, and he was like, yeah, that's tough to get around. Tough to get
That's
around
really tough.
that the docket number announced is for parties that are just now getting here, and I'm trying to kick them out. Yeah.
And I'm trying to not only kick them out, not give them the ability to say anything, which obviously it didn't matter what they said, because the Tate team, and in terms of all sorts of stuff, wasn't even. Where is that? Who's on that Tate team? Come on, identify yourself.
Yeah,
Come on
really.
here. We really would love to
They
hear from you.
tain't no good.
But who is on that Tate team? Who is?
Yeah.
Does anyone know? If you know, please tell us. Oasis Cat. Any legal
You just got rid
reason?
of another one of my questions.
I did. How did I
Yeah.
do that?
I don't know. I think you just did. Let's go back. We'll get to hers too. This is Mr. Stanley again, or Miss Stanley. I don't know. Does the defense now have to be strategic with asking for sidebars after this objection ruling, as it might annoy the jury having a sidebar? Well, I think that's always true. I think it always annoys them. But now the judge has effectively said, we're going to have more of them because you can't even give the basis for the objection. And if you want a sidebar to talk about it, we're going to have them. So it's bad form. It's bad for appellate purposes if necessary. It's bad to keep because it doesn't keep the attorneys focused on what the grounds are. And then it encourages sidebars to fix that problem.
Yeah, and the interesting thing is, I think, who was it that argued this? Was it Mr. Yannetti? I believe it was. It puts us in a position of making us look bad. We have to decide whether or not
Yeah, he
we're
did.
going. Yeah, going to
What
have
I
us.
like about him, he's so honest. He's like, there were some objections. I had no idea what the grounds were. And then the court rules, and I'm not sure what the court's ruling on. That's the problem.
Yeah, and he said this so that, but it makes us look bad. So we either have to figure out whether we're going to object. We're going to go to cyber to look bad, or go to cyber because we got to protect the record and we have to understand what's happening for our
Hmm.
client.
And
And
annoyed that, to Samuel Stanley's point, juries don't like that. They don't like it at all. They feel
yeah,
like, what are you talking about that we don't get to hear? That's on a human level. It's like people whispering across the room. You want to
yeah,
know.
yeah.
And it's like, mate, this is our time. We're not here because we got nothing else to do. So please respect our time.
Speaking about time, given the amount of arguments we've seen now, although I'm getting a hint here, I'm beginning to think that she's going to limit the time. And I don't know how you can limit the time for a criminal defendant. You can limit it in a civil case, like we saw in Johnny Depp. You can say each side has, X amount of minutes, right? And we use those minutes, that's it. So you're limiting. But I'm not sure how that works in a criminal case, or whether that's a violation of due process here. Because this case we're talking about initially was 6 weeks. This case ain't going to be done in 6 weeks. Ain't no possible way.
And again, that's just assuming that we're not counting the jury selection process, which is technically part of the trial. But that's going to be some time. Did you find the question that I yanked away from you there?
No, Misty's going to have to find the question that
Okay.
yanked away. In the meantime, Oasis Cat has a couple questions. Question. Any legal reason why Judge Cannoni is so insistent on the April 1st jury selection date, and with potential jurors that summonses have gone out already for? Because she said it costs like $10,000 or something.
So she also said that if we have to start over, she made it sound like I've investigated this, like she anticipated these arguments. She talked to whomever they use for their jury coordinator, 10 weeks, 10 weeks to get back up to the number of people they now have ready to go and to report on April 1st. So I don't know what that number is. She's never given that number, but she says that having talked to the jury coordinator to repeat what they've already got set up, it'll take 10 weeks to do that.
So that's why she's wants to do the jury selection and not swear them until everything, all the ducks are in a row. And in a way, if you recall, didn't that happen in one of the Durst cases, right, or something? There was a case that the jury wasn't sworn.
Oh no, yeah. I thought it was YSL, but maybe I don't know about.
Maybe Durst. It was YSL.
There was like a 6-month break between
because of COVID,
seating them and swearing them in. And beginning the trial. So Scott adds that he thinks they summoned far higher than the normal potential jurors, whatever that normal is, for April 1st. And so she wants to stick with it as far as beginning jury selection. Yeah, I get that. This was enlightening when somebody asked the question about the continuance. I think it came up first yesterday as we were talking about it. That's the first time she suggested in open court how long it might take to impanel a jury. There was never any discussion. People have wild ideas. I don't know, this kind of case, the size of the jury pool, who knows? And she said, it could be you're trying to get a continuance up through the 28th. It could take that long to get a jury. So that's in her mind as part of the whole scheduling process.
Right. And then what she said is because the defense wanted to wait until the circuit court acted on the issue of the double jeopardy, say, well, we could have an opinion by the 25th, and that would solve all of that problem. So we just don't have to swear them to get that double jeopardy.
And the problem is, unfortunately, it's the crapshoot. Nobody knows. You're not going to get an advisory scheduling from the appellate court. Well, we got this on our schedule for the 23rd. Does that work for you guys? Because that's not going to happen. So they know this is happening. The appellate court knows what's happening below. So they will make a conscious decision to either render a decision beforehand or just wait till the trial's over, because I think it'd be suicide to render a decision mid-trial unless it was a flat denial of any appeal.
Right, exactly. You're absolutely right. Oasis Cat also follows up. Do you think that Hank Brennan added the defense attorneys to the Commonwealth witness list due to the fact that Karen Reed talked about conversations with Yannetti and the documentary people around them filming. Oh, interesting point. I thought it may have to do with the phone, that he already thought there's issues in the phone. But that's an interesting point, because he brought up this documentary, which I haven't seen, by the way. In the chat here, you tell us if you've seen the documentary. I know Michael Bryan
and
has.
your thoughts on it too. Having produced a number of docuseries and worked on a number of them, I think it was decently done. You know, that's high praise from me. I think it was decently done. I think.
Excuse me, can I stop? I'm going to interrupt you. That is true. Michael Bryan does not give high praise. The only people he really
Not to
praises
me,
are,
not to anybody.
well, our producers. You praise
Well, that's
them
true.
up
That's
over
true.
there, right?
Yeah.
Okay, sorry.
But yeah, I mean, you know, this is like, you know, you have you know, a car that you show in car shows, and you're looking at the other ones like, you know, it's okay. But I think it was done decently. I think they had great access, which is key to these kinds of shows. You know, the whole we're riding to the, you know, the court, waiting for the you know, the verdict, and they had all those moments. It was great. I think she came off pretty even-handedly. They had a couple of folks. I'd like to hear what our people think about what they saw, but they had a couple of folks that to me were sort of plants, sort of they needed a contrary position. It's easy to get pro Karen Reed people, but to tell a story like this, you really need to have the other side. And they had a couple of folks that to me were not real high-profile people that I've seen before making the argument for her conviction. But they did have those, and some of them, you know, I've shaken my head at some of their analysis, but just my opinion versus theirs. But on the whole, I thought it was decent.
Interesting. I'm going to have to take the time.
I would definitely watch it. Yeah.
To watch it. There goes my Wednesday night, as it hasn't gone already. Anyone knows me knows that I watch PBS and my animal programs. My nature on PBS is like, you know, where I'm at. Nature and Nova, you know. And someone says to me, "What? You never seen this?" And nope, never seen it. If it doesn't involve animals, and I'm not watching it. You know. Okay.
Well, this
But
has
that's
different
just me.
animals involved, so try to, you know.
This is like the human animal. Okay. I don't know. Did I get rid of another question? I don't know what I'm doing here. I shouldn't be allowed to touch this thing.
Yes. Okay.
Okay.
Tubular. Get that? Tubular. Not
Tubular.
YouTuber. Tubular.
That's great. Tubular.
Yeah.
Okay. It was such a small court, and you've been in the courtroom, so I want to throw this to you. Can the O'Keefe side of the court hear the conversations in the sidebar?
Very interesting. And by O'Keefe's side of the court, I'm going to assume they mean the gallery. I don't know. And the gallery, small as it is, has like a, you know, those retaining straps they use for going into a club or going to the movies or something. You know, it recoils. It's like a seat belt. They have that right down the middle of the seats, and you can kind of see it from some of the camera angles. It's one bench with this right down the middle, splitting the sides. So one side is predominantly the O'Keefe family. But you also notice that there are O'Keefe family members that are facing the camera. They're not in that split area. They're facing the camera, and right behind them are journalists like Ms. Rex, who's from one of the locals, I think 25, and Matt from Court TV is over there, and Aiden is up on that little elevated area as well. It's so small, I don't know how anybody in that room can't hear at least bits and pieces of a sidebar. Now they use the white noise there, as I recall, right?
Right, they do. Right, yes.
And that's very effective. But the sidebars, and I think this is important, are on the opposite side of the judge's bench to the jury. So you do have that structure in between the conversation and the jury. So it's probably harder to, if at all, to see lips. And there's a lot of furniture between the sidebar and the jury. So,
Wow.
But I think people in the courtroom, I definitely on that side of the bench have a good shot at hearing something.
It's at least something. Okay.
Something.
So then we go to Samuel Stanley. A question. If Monday morning quarterback, if you're a Monday morning quarterback, do you pick a lessee for opening, or who would you like? In federal rulers, you can time limit the prosecution as it came up in the YSL trial. Okay. Well, we know one thing. We know that she was asked specifically whether or not Mr. Yannetti was doing the opening this time, and the answer is no.
Yeah, it's too bad. I think he did a good job.
I think he did a great job. Yeah. I don't think it's a lessee doing the opening. I think that
You think
Alan
it's
Jackson's
Alan
doing the
Jackson?
opening,
I mean, he
and
killed the closing, obviously.
yeah, I think he's doing the opening, and maybe they'll split the closing with he and the lessee. Quite frankly, I think that you take the person who has the jury experience a lot, or you take the lead trial team leader, and maybe Yannetti and Jackson split the closing.
That I could see
Okay,
that maybe.
yeah, because
Um,
because he's home. He's home. I don't see Alessi doing the opening. I think it's
No,
Alan.
I think Alessi was brought in for the technical arguments, for all these motions, for all these legal. That's his style. It's not as warm and fuzzy as you might want it to be in front of a jury. I think he's earning his money now, and I think once the trial starts, he's going to take a much further back seat.
Somebody said I saw, and I don't know if it's true, that he was doing this pro bono. I don't know if that's true or
I
not.
do not have
Yeah,
independent confirmation of
I
that.
have no confirmation of that at all. So yeah, no, I would not would not pick him. You got to have a you got to have somebody who knows the jury. I think they had Yannetti last time because he was a known quantity in Boston, and you want to have him inure to the local home people, so to speak. But I think now so many people have watched Jackson that he's kind of like a local home person for the purposes of doing the opening. And Alan
Yeah, and I also
Jackson
think maybe a little
has experience.
respect for Yannetti, within the team. That now, for the same reason as I'm all hung up here in my wires, for the same reason that you
Please
mentioned,
don't strangle yourself.
everybody
Please.
is comfortable now with
Yeah.
with somebody other than Yannetti, and yeah, I mean Jackson, he's so solid in front of the jury.
Yeah. Question. Do you believe Karen will win her federal appeal on the charges? So this trial will be solely on one count, the lesser. That's the manslaughter count. Okay. Michael?
Actually, I was spooling my cords. Federal appeal on the charges. So this trial will be so. Oh, I see. Do you think? No, I don't think they're going to win on appeal. I don't. I just think the distance, the time lapse between the declaring of the mistrial and then the affidavits that started filtering out and became part of the original motion for new trial, and then appeal number one and now appeal number two. Too much time. Every day that nothing happens is a day that hurts their case because the jury members are now exposed to who knows what.
Right. And you
We've
don't
said
have
many
all
times.
12 of them. You don't have all 12
Yeah,
of them that submitted affidavits.
yeah.
The ship, and I think it's really unfair to the defense in the sense of, had she done it right away,
Yep.
you would have had a good feel.
And this
You
is
brought everybody in, and she could have done that. This was within a week.
I hadn't seen it in a while, and I watched last night because the last episode is basically about the trial and the result. Spoiler alert: it's a hung jury, and so she's reading it, and I literally timed how long it was between her reading the note. Remember, the last note
Right.
was very well written and very well crafted, so that it'd be tough for her to say, "Get back in there one more time." Right? She'd already given the dynamite charge, and this helped her. Long note about how each side was entrenched. Right? So from the moment she reads that to the moment she says, "I'm not going to make you work anymore. I'm declaring mistrial," it was 3 seconds.
Oh,
So
really? It was.
yeah,
That's how
it
quick it
was
was. Wow.
it was that fast.
Wow.
So yeah, there was no time for her to correct any mistakes that she had made, either in failing to instruct them that you could come to a unanimous decision on any or all counts.
Or have
Cor-
you? Have you come to
That's the question. Yeah,
the
I think there are
question
two
is,
ways to
have you?
fix it. The
Right.
first way is a legislative, which they don't have, which is we need a jury instruction that says very clearly, if you come to a unanimous decision on any of the counts, blah blah blah. That's number one. That helps the judge, prevents the judge from screwing up like the judge did. Asking after the fact is the other way the judge can help him or herself, and neither of those things happen.
Or telling, as they did in Judge Walsh. Was it Judge Walsh? It sounds so far now. ASAP Rocky, right? This case
Oh,
is
Judge
part of the
Arnold. Judge
Judge
Arnold.
Arnold. I apologize.
Yeah.
Judge Arnold is part of the jury instruction going in. it's part of the jury instruction. If you come to a decision on any count but are hung on others, please let me know. Or you can come to a decision and be hung on some. Just let me know. I
Yeah.
mean, it's told to them right off the
Yeah,
bat.
that's the
These are
California
people.
legislature. They did that right.
Okay.
Massachusetts does not.
Yeah, it's so easy. And look, I've tried cases my whole life. That's always a situation. If you start with you get a hung, the judge will then ask, you come to a verdict on any of the counts,
Yeah, and man, it
Yeah.
puts you, people are ragging on the defense. They should have said something. You're in a weird position as the defense. Do you want to, as they say, press for an answer you don't want to hear? Your Honor, let's find out if they were unanimous on anything. Oh, okay, yeah, they found her unanimously guilty.
Right,
you,
right. And then just
you don't
send
know.
your law degree home and your malpractice policy, because you're
Yes,
representing your client.
call your
Uh,
carrier, as we say.
Call your
Call your
carrier.
carrier.
Yeah.
Yes.
Tara Alice question. It's clear Judge Canoni does not like Alan Jackson. Do lawyers care about that?
Hmm.
I feel she doesn't give them any wins because of her dislike of Karen Alan Jackson. Let me just say one thing before I'm going to throw this to you. There was a sidebar early this week when we started where, remember, Karen Reed was called to sidebar before the judge ruled on, completely ruled on the Rule 14 violation, where she said, and I find that the defense is misleading. But before I impose any sanctions, I'm going to want to see Karen Reed at sidebar. I think at that point she said, I have found that your lawyers have lied to me a number of times. That could affect, whether or not you have a proper and fair trial in this case. Do you want to continue, or do you want different lawyers? And if she was like, you want different lawyers, what was she going to do? Get rid of the whole team? Or was she just saying, I find that Alan Jackson lied to me, if that's what she said, and you can keep Mr. Yannetti because he can try this case?
Yeah, that's a sidebar I would have loved to have been
That's the one we
eavesdropping
want.
on, right?
That's the one we want,
Because
right?
she could have been she could have been putting Karen Reed in the old headlock. Like you could lose one of your attorneys, you could lose all of them. I almost wish she had called her bluff. Like, well, I'll just get a whole new team.
Yeah, because what is she going to do? Say, okay, I'll
Where are
have
we
Mr.
now?
Yannetti
April
try it.
1st is out the door.
Yeah, right. Yeah, I feel she doesn't give them any wins because that's like I think it's been a change. I really go back and watch the trial if you can, and you will. And then the trial was fine, and then when you get to this whole thing about the Hank Brennan coming in with this, it's got to be an ethical violation, and then Alessi, as Hank Brennan calls him, has to defend the case by saying, no, it's not ethical. At the most, it's a Rule 14, which is a discovery violation, which happens all the time, okay? But prosecutors all the time. Think about A$AP Rocky. Oh, I have a 25-page report here for the patient. We just didn't give it to you as we're about to open today.
Whoops. I find no intentional misrepresentation. Judge Arnold, he was bending over backwards to let it fly. And as it turns out, everybody was happy. Well, not Lewin. So to Tara's point, I don't think any attorney gives a rip whether the judge likes them or not on a personal level. They do care if it impacts how their client's interests are affected and their right to a fair trial. So you'd have to kind of split that question. Personally, who gives a shit what the judge thinks of me, as long as I'm doing the right thing for my client.
Right. But I know it does put Louise Powell. Question. Why do judges have so much unchecked power even when we can all see the bias, Michael?
Yeah, well, in this case, part of it is appointed judges. That's part of it. If a judge can't be voted out, they tend to be a little cockier. And if they are appointed by someone higher up that agrees with what they're doing, man, they're golden. So that's and if you talk to any of these supporters up there in that Canton, Dedham, Stoughton area, they all see it in a much more detailed way than I've ever been able to experience. But I get it. I've just sampled it. We both sampled it, just seeing this unfold. And it's big. It comes from the top, as they say. And if it comes from the top, you're good if you're one of the appointed judges.
Well, I find judges have that power in almost all cases. They're always anti-defense, okay, as far as I'm concerned. They were even all anti-defense in YSL until we had Judge Paige Whitney come back in, who then kind of, saw what was happening. And she kind of righted the ship there the judge in Albuquerque. Was it Albuquerque, New Mexico, where Baldwin was tried? It was in New Mexico, right?
It was Albuquerque.
Yeah. I mean, that was very unusual. But usually when we're in the trenches, we feel like we're under attack as defense attorneys all the time with that unchecked power. And I think it happens, Michael, also in elected judges too. I'm from New Jersey, where judges are appointed, but we have a very interesting system in New Jersey in terms of appointment. It's one Republican, one Democrat. One Republican, one Democrat gets appointed, so you have an even bench. But in New York, judges are elected, and you see decisions where judges will come to a decision, and then there'll be public outrage, and there'll be a call for, impeachment, removal, whatever. So I don't know what the answer is, except to have an honest judge trying to do the right thing.
Crazy idea.
Oh, what a possibly crazy idea. We have a lot more questions. Micah, I hope you've gotten your mug. I know it's on the way.
You're pressuring the Postal Service, but I'm sure Micah will let us know when it arrives.
You have to try a case and have to choose one of the following as co-counsel. You have to choose at least one of the following. Miss, I'm going to throw this to Micah.
Oh my gosh.
Miss Love.
That's a great question.
Hank Brent is a great question. B. Lally. C. I can't even say.
Well,
I know Lewin, by the way, remember, he went after me personally because Justice Serve TV had 3 scoops that were double sourced in the ASAP Rocky case, and he was PO'd, to say the least. He was ticked off, and he wouldn't mention my name. He could say, and the person who scooped this happens to be X, Y, and Z. Everyone knew who he was talking about, but he wouldn't mention my name.
I know, that was funny, and they dragged my name into it. Don't drag me into this.
Yeah, they dragged your name into it.
I forgot to tell ASAP Joe Tacopina. So Joe, you throw out my name. Could you at least given us a Justice Serve TV plug? Give us something.
Yeah, we have to talk to Joe too. I want to find out whether or not any of the sidebars have been released in that case by now, and whether or not the attorneys had to pay any fines. We got to find out those answers to those 2 questions.
Oh, that's right. They were running the tote board. Yeah.
Sidebars and fines. Okay, let's remember to do that, Michael, in our spare time. We love Joe Tacopina.
We get right on that.
Yeah, well, absolutely, it's important. Okay, so you have to, and everybody here should answer. Matter of fact, this would be a really good poll question to put up tomorrow. Okay.
What's that?
This one, you have to choose to try a case and have co-counsel. Who do you want?
Oh, sorry, you were talking about Lewin and he popped in. Sorry.
Miss Love, Mr. Brennan, and Mr. I'm going to choose Lally because I can give him a work, and I think that he would do the work. He doesn't have to be upfront and personal in front of a jury.
You would browbeat Lally. I get it.
Yeah. No, I wouldn't browbeat him. I just want somebody to do. I'm not going to have somebody who's going to put a whole team in jeopardy by either whining her way and filibustering, or Mr. Brennan, who I had said was a good attorney, no matter what you thought about. But today, with the way he conducted himself, he may be a good attorney, but I had lesser respect for him, shall we say, after today.
Okay, I have a surprise answer. And first of all, there's no indication as to whether it would be for the prosecution or the defense. So, because I think that might affect my choice. But I'm going to go with Miss Love because I think she can be used. I think she can be a great tool as a combo. On her own, I think she's a bit of a wild card. But I think if you guide her properly, I think she could be useful.
Yeah, and apparently the next case she was assigned to, she was second chair. She wasn't first chair. So yeah, obviously that may be involved. Very, very interesting how we pick people to be on teams. So that was a great question, Micah. ADHD in the making question. Can out-of-state judges who don't agree with her standards petition, I think, to higher-ups to have her removed because Massachusetts, she can't, she's ahead of the judges. Yeah, and she has great respect in Massachusetts. I told you, she did the whole rule changes. And by the way, those rule changes that she did, they're great. They're helpful for the defense. They're terrific rule changes. She has great respect, and she's probably going to go to the Supreme Judicial Court in Massachusetts one of these days.
Yeah, but out-of-state judges really aren't going to have much to say about who's on the bench in Massachusetts.
Yep. Yeah.
There's just no standing for an out-of-state judge to do anything about another out-of-state judge.
Okay. CLK, do you think the defense should hold their opening until after the Commonwealth? Would that be better? My answer, no, no, and no. By the way, where are you from, CLK? Are you from, oh, I see you have the British flag. Fine.
Yes.
Okay. The
'Cause
defense
she's got,
with state.
he or she has the
Yes,
defense
defense
with the
with state.
C.
Absolutely no. Jurors have a bent after an opening, okay? And they have to have something to counteract that bent. They come to a bent. 60 to 80% of them come to a bent. Some of the figures now are changing to 50 to 70%, but whatever it is. A large part of them have, not that they've made up a mind, but they have a bent. So whatever that bent is, you're starting from, shall we use the phrase, behind the 8 ball that you have in your
here
toolkit?
somewhere. Yeah.
Yeah, that 8 ball that you have in your
We need to
toolkit,
give
right?
Judge Bev that. Maybe she'll answer some,
Yeah.
from the bench.
But so that you're going to have to, since you're already starting, if you are, people think that the prosecution has kind of made their case and they've already bent that way, you better have started to try to like chip away right away. And you can't afford to wait on a case like this until after the state presents the case. You just can't.
Yeah, it's a tricky one. Sometimes I look at how strong the prosecution's case is to help make that decision, but I think generally you're right. I don't want to let what they've had to say in openings just hang there, for days.
Okay, weeks. It could be weeks.
Yeah, you're right. So
Amelia
we're staying on the other side of the pond. It looks like for Amelia
I love the
Walsh.
other side of the pond. I have a great client
It's
on the other
past your
side of the pond.
bedtime. It's got to be like 1 or so in the
Well,
morning.
we have a producer who is from Ireland, right? We have a number of people who are overseas that help this show.
No doubt.
As you all know, we're young. We started in earnest about 5-6 months ago, and we're trying to make it grow. And with people like you who are watching, all of our viewers. And by the way, before I read Amelia's question, please hit that like button right now, because we have nearly 400 of you watching. Or doing questions, because we can't, you have to subscribe to add, subscriber mode's on to ask that question. So please subscribe, but hit that like button. That gets us into the YouTube algorithm.
Yep.
Amelia
So
Walsh.
those that are overseas, your insomnia is our benefit. Thank you so much.
Yes, thank you very much. With Judge Cannoni's grave concerns and harsh words of the defense, and yet zero sanctions, can her funds follow them into their career? Well, we don't know whether there were sanctions, do we, Michael?
No, we assume not, but it could have all happened at the bench. We just don't know. She could have said, okay, Ms. Reed, I'm going to follow your desires. You're going to keep your team, but I'm sanctioning each of you $1,500. I mean, we don't know. We have no idea.
Yeah, or I'm going to not let your counsel come in and try a second case for a Procedural case for a year or something like that. I'll let him do your case, but after your case, he can't. Something we don't know. We don't know what, if anything, was said. I'm just making that up because they can do anything. So whatever it is, hopefully it won't follow anybody's career, because that would be another true tragedy here.
We did. I knew I was going to do that. I just bumped yours out. Let me do
you
this.
Bump my question out. Okay.
So confused.
I don't know how to bring mine back. Missy Mayhem, we need help. We have to bring the question back.
Was that a starred question or was that a regular question?
Yes, it was a starred question.
Oh, then it's got to be in there somewhere, right?
Yeah.
So confused at the closing of court today. Is there another Karen hearing? No, you would think so. There might be some, not a midnight judge, but an afternoon ruling for a Friday afternoon. But yeah, they continually move the schedule around. It was going to be all Tuesday and maybe leftovers, but they barely started Tuesday, pushed it to today, then only went till 3:00 and pushed the balance to Monday. So Lucy in the sky, it now looks like Monday.
Yeah, and the confusion was because she said we'll do that tomorrow at 9:00, and I think I texted you, 9:00 tomorrow, Michael. I have to do another interview at
that's not good.
10:30 to 11:30, and then we're also doing an interview, and we'll announce it after. That will be a premiere for tomorrow night at 5:00, because we don't know whether or not there's going to be motion rulings. There's got to be orders that come out on all this stuff, right?
You would think.
So one would think. So yes, we're all we'll try to keep on top of keeping on, but that's why sometimes we don't get our thumbnail with our notice of when we're going live out, because we're waiting for things to happen, because It's all very, and if you imagine we feel this way, imagine how the defense team feels, right? Oh my
Yeah.
gosh.
Like I said, my motto always was a surprise a day, but this case is surprises per day. And they're not necessarily from the other side, they're from the bench.
Let's do 2 more questions, then I'll go look for the other starred questions that you knocked off and I knocked off. Question. Now from Scott. Scott, are you here? You're in the chat. Thank you. Scott was on. Was it just last night? I mean, the way things are
I think
going.
it was 2 nights ago. I think it was Tuesday night. Yeah.
Now fired Proctor, that's Trooper Michael Proctor, is on the defense witness list. Can they impeach him as a hostile witness they call? Michael.
Is there any doubt? You have to see how it begins. Obviously, without some foundation suggesting he is hostile, I'm not sure you can make that argument. But we start to get into some questioning, you can certainly make that request, treat him as a hostile witness. And all it really means is on direct, you get to ask more pointed questions, more leading questions. So instead of saying, Mr. Proctor, when did you leave when did you leave the Massachusetts State Police? You can say, isn't it true you were fired from the Massachusetts State Police? So it could happen. I don't know.
Okay. Interesting. I want to know whether or not the state, the Commonwealth, intends to try their case without calling him. I bet you they try that. I bet you they try to try the case without calling him.
It is. I'm telling you, it's a tough nut because it's bad. It's bad either way. Whether you don't call the lead prosecutor or you call him and have to put out every single fire that he started in trial number 1, and now that he's been fired. Speaking of fires.
Yeah, thinking about fires. Louise Powell, I wonder if Proctor will take the 5th, or is he allowed to? That's kind of an interesting thing. Well, if you're going to start accusing him of a crime,
I mean, not everything has been, litigated as it relates to him. He lost his job, but that's a civil process, really. There could still be criminal charges hanging out there, spoliation of evidence, witness tampering, perhaps. So yeah, I don't know.
But there is some indication he testified in the federal investigation, and also he testified before his hearing. So it sounds like he has not taken the 5th at this point. And they feel there's no need to. But that doesn't mean that he couldn't choose to at some point in the future.
Depends on what he's asked. Yep.
It depends on what he's asked. Yeah, very interesting question. Michael, why don't you continue on with these while I go look for the questions that were bounced.
Okay. I'm looking at what's left of those here.
There's a lot, and they're being added. Keep adding them. Come on, everyone wants their questions asked.
Okay, Bev changing day and times, that alone is wrong. Then add the rest. Has she? This is Mary Romine. Has she approved anything for the defense? Just a clean approval. I don't think anything that hasn't been approved or agreed upon with the Commonwealth. I don't think there's been any contested issue. I may be missing one, but I don't remember any contested issue where Judge Bev sided with the defense.
Yeah, I don't either. As I'm
anybody else hears of one, remembers one, let us know. But not totally contested. Uncontested, right. Even then, sometimes she made them make an argument, even if it was uncontested.
Yeah, I don't remember. All of you are really into this case. And, we're doing a lot of cases, including our own law practices at the same time. So sometimes things could get a little fuzzy. I think we have a pretty good recollection, though, of most of the things that are very, very important, right?
As for taking the 5th, Oasis Cat says, do you think Brian Higgins, Colin Albert will take the 5th now that you just dumped my question?
I'm sorry, I shouldn't be allowed. Missy, I need help. I shouldn't be allowed to handle. That's why they don't let me handle the tech when I'm giving a closing.
Okay, I'm going to get rid of that, right? Keep an eye on wherever that was so I can finish this one, since they've been named as third-party culprits. To me, that was one of the big wow moments of today, was when, they've had this argument about third-party culprits and this related issue as to an expert who's going to testify that the investigation was crap, right? That was the legal term I'm sure he's going to be using. It's a horrible investigation. And the Commonwealth is concerned that will help promote the defense argument that a third party was involved. Why? Well, if you did such a horrible investigation, you didn't know that a third party would be involved. And for the first time, Unetti stands up and says, we have evidence that we're going to present. I'm hesitant to do it, now in this forum, open court, prior to trial. But there are three people that we're focusing on as third-party culprits, because the way the law is set up in Massachusetts, you don't necessarily have to have a target in terms of what do we call it? Some other dude did it. You don't have to have that specific a target, but you do have to have some evidence, not just throw out there in the wind, hey, somebody else might have done it, which is kind of the Richard Allen case, right?
Yeah.
The Delphi case was kind of like,
Yeah.
well, it wasn't him. Well, who was it? I don't know. Anyway, so at that point, Yannetti said, yeah, we're looking at Brian Albert, we're looking at Brian Higgins, and we're looking at Colin Albert. So for the first time, those three have been now identified by the defense as targets of any third-party culprit analysis. So that's big stuff.
Yeah. And I think what happened, if you recall, it was early, and I think it was last week that Hank Brennan said, when Karen Reed gave the interview to Daniels, right? She said that she knew or something who had. I'm not sure if it was her or Alan Jackson. Alan Jackson said they knew who'd killed him, but on the interview he said he didn't know. But it was because they weren't picking between one of three people, and they didn't know. I think they said in court it meant that we were saying it was somebody in the house, but we didn't know who it was. Not that we didn't know who it was.
Exactly.
I mean,
Yeah. We don't know who did it, and they were focusing on that. See, they don't know who did it. Well,
right.
No, they don't know of those in the house who did it, but they know who was in the house.
And that's what they're saying. That's their argument. And I see there's
Yeah.
a lot of people, there's somebody else in the chat who thinks that Karen Reed is definitely the killer. And
Okay.
Just please be respectful when you're talking about it. There's no need to have a lot of different, she's the killer, ha ha ha. We're trying to be respectful here. All right. So thank you very much for coming. Anyhow, Zelda Bot. Could Karen's team call Lally as a witness due to Brennan adding her team to the witness list today? I don't think so. I don't think so. I mean, didn't Lally speak today? Did I hear him speak? I thought I heard something that he may have said something. Anyhow, I kind of feel bad for him because
well, if you watch that
anyway.
special,
By the way, thank you, Zeldabot. If I watch,
you're really going to feel sorry for him, because it's a stark reminder of his struggles in the first trial. I mean, just performance-wise, he may be great behind the scenes putting stuff together, but man, it was rough. It was very rough. That and also,
but I feel bad
officer.
but here's where I feel bad. I mean, they brought in a special prosecutor, obviously Lally, and who is the other assistant who's there. You have to sit there, and they're just sitting there.
Oh, I know. I know.
I feel bad for. I'd feel bad for anybody.
Another thing I'd like to know, because we've seen this before, has happened where, hey, sorry, we're pulling you, we're giving you the hook, and then that person isn't sitting there at the defense table anymore, right? So I just wonder how it was approached with Lally. Was it, we need you there because you know more about this case than anybody else? We need you there because we'll look better because we aren't firing you. You're still part of the team. Did he want to be on? Did he beg to be off and they wouldn't let him? I'd love to know all that.
Yeah, I'd like to know that. And I think someday he will probably tell us, but not now.
He'll tell us in that book.
Amelia Walsh, £5 donation. Thank you. So glad I found you both. Your take is so incredibly informative. Now you are my bedtime sleep routine. So great. Much to my husband's dismay. Bring your husband up. Let him watch.
I've been known to put people to sleep before, so I understand that. Yeah.
No, let him watch. Thank you. Thank you very, very much, because we appreciate it. And we call it as we see it, and I think we said at the first trial, look, we don't think 1 and 3 is proven, but we could see where a jury could have different takes on whether or not she not hit him with the taillight, but maybe nudged him a little bit, and because he was so drunk he fell. We see that as a possibility.
I mean, he could have been, this is another scenario I just thought of, he could have been steadying himself on the vehicle, right? And she pulls away.
Right.
And he tumbles. I mean,
anything.
Again, if you don't know what happened, the prosecution has not proven its case. Do you want to get into any of the video before we? I don't know what.
Yeah, I do. I just want to do one more thing. I just was trying to, because we've asked people to come here and bring their questions tonight.
Yeah.
Lisa Harris, I was happy Yannetti stood up to Bev and did not back down.
Definitely.
Yeah, they're not back down. Yeah.
That's because we
So,
saw. In fact, I think I have that. Let me see if I can.
and
If
let's
there's.
see, yeah, and I think then we can go into some. We have some video. We wanted to show. I know we tried to start do an hour type, but you all came with the questions we asked you to come with, and here we are. We're answering your questions. So if we're going a little longer, we apologize, and we hope that this is what you want. You wanted us to answer your questions,
And
and we're
nighty
not
night.
boring you. And, and 99.
Okay, so here's we may play a little true crime roulette at some
Okay.
point. Wait, hold on a second. I just wonder why we keep now we get our little pictures are in circles now. It just seems weird to me. See, why is that?
Yeah.
Anyway, let me jump to one of the
Where-
first ones I thought was most interesting. Remember there were technical problems today. It was so frustrating.
Oh.
Anytime you see that boop, that's not us. That's the feed, and I don't know why. But the ARCA issues continue to be, hey, look at, there's the fan, forward, back, forward, back. ARCA issues continue to be a problem for
Who
everybody.
decided what materials to give them? We do not know what materials in totality they viewed. We know many of the materials that they weren't given.
And again, he's
so
talking about
clearly
ARCA.
there is a undefined relationship between the defense and the United States Attorney's Office around this time of this investigation. And we subsequently learned that there was a continued relationship. And so today, as we sit here, we really don't know. What we know is ARCA listed materials that they reviewed that came from our discovery that we didn't provide. What we know is there was materials that they didn't review that were inculpatory. And so that's why we began by asking for discovery. We filed an extensive motion for discovery that the court allowed. It still hasn't been complied with. Perhaps some of it through no fault of the defense, because I don't think they will be able to comply with much of it. Other Rule 14 discovery obligations have not been complied with. We've received no information since that production on February 13th, nothing. And we know just inherently from that information that there is more. There are more communications, there's more interaction. And so it would be misleading to have ARCA witnesses get on the stand and then suggest that they were independently hired by the federal government and all of their attempts and efforts and report was wholly and entirely objective. Just to give one point that emphasizes the concern, the ARCA witnesses were never given information about DNA. And yet when they testified, one of the witnesses tried to address the issue of DNA because it was hurtful to their position. In their report, they say one of the reasons why they believe that there was no impact between the car and Mr. O'Keefe is because there was no DNA. Well, in fact, there was. There was DNA, and separately there was a hair, Mr. O'Keefe's hair. And so we know they didn't have all of the inculpatory information, and then the question still remains, how did they learn of that? How did they learn of that information before cross-examination? And so I think what is most appropriate before Your Honor makes a decision on the so-called objectivity of these witnesses is they should come into court before trial, well before trial, and they should answer questions about their directives from the United States Attorney's Office. They should answer questions about the materials they received. They should answer questions about what they were told or what they knew about the case. They should answer questions about all of their correspondence with the defense, including phone calls, emails, text messages. All that should be produced. It's not a Lanigan hearing where I question their qualifications, but if we're truly going to think about presenting them as objective witnesses, they truly should be objective. And I think if we have an opportunity to question these witnesses, we will learn much more about the relationship. Inevitably, even if the ARCA witnesses come in to be questioned, as they should, well before trial, in my opinion, we do not have the opportunity to question the United States Attorney's Office. We're resigned to TUI letters, which inevitably have been unhelpful. And so I think it sets a bad playing ground to have them get up and say they were hired by the federal government, because then the Commonwealth will be inclined to explain the inculpatory evidence the role of the federal government, the limitations of the federal government, the fact that the federal government has closed this entire case in all related investigations, which implies something quite the opposite of what the defense would like to propose. And so in a vacuum, it would be misleading. I think what the court ultimately should do is they should present these witnesses as they did at the first trial. They were hired independently, and then subsequent to that, the defense retain them if that's what they chose to do. We still don't know that because we don't have any Rule 14 discovery. And inevitably at trial, part of the credibility issue will be the information that they considered and the limitations on it, and ask them why they didn't ask for more information or why they didn't receive more information. Notably, we still don't have an answer to Mr. Klein, who was the third biomechanic person involved. And
Is his name on the witness list?
I haven't seen it on the witness list.
No, Your Honor.
And we still don't know why the defense chose to call 2 of 3. As you noted, that report is vague. And so it doesn't identify or articulate which witness did what. So it's impossible for me to imagine how you would choose 2 of 3 of those witnesses. But more importantly, you can't effectively cross-examine a witness because, as we saw from the second witness, Dr. Rentschler, when he disputed DNA, which we don't know where the source of that came from, he is not held to the opinion in the report saying that we would have found DNA. He can simply defer and say that was somebody else. That could have been Mr. Klein, could have been Mr. Wolf. We don't know. So that report really is quite unhelpful. And I think we need answers to these questions before any of these witnesses testify. And I do not want to be moving during trial to exclude the defense witnesses for failure to comply, but we haven't seen compliance, and I don't think we will. So my suggestion is to follow the protocol of the last trial, but before that, these witnesses should be brought in so that we can obtain actual records, not just asking the questions and rely on their word. I think based on their past performances, that's insufficient. I think we should have a right to the records to demonstrate the relationship.
Mr. Yannetti?
Thank you, Your Honor.
Now remember what this fight is about. This is about whether or not these ACA experts
Your Honor, the
and their relationship with the defense.
Commonwealth and the defense certainly have opposite arguments when it comes to what the jury should be allowed to hear about how the ARCA witnesses became involved in this case. Mr. Brennan speaks about the heart of our motion. The heart of our motion is that the Commonwealth wants to hide the truth from the jury. The defense wants the jury to know the truth. In the first trial, this court disallowed the ARCA witnesses from testifying about who hired them. We were therefore forced to ask oblique questions, trying to show the jury that we didn't hire them, that we didn't provide them with information, that we didn't influence their opinions and conclusions. But we weren't allowed to tell the jury that the Department of Justice, the U.S. Attorney's Office, hired them. So the jury was left to speculate about how they became involved. I think the court will agree that it's ironic in a way that the court excluded mention of the Department of Justice and the U.S. Attorney's Office because the court rightly did not want the jury to speculate about a federal investigation. But by excluding mention of the federal government having retained ARCA, the jury was left to speculate incorrectly about how they became involved.
They were also instructed more than once not to speculate,
And,
right?
but the point of the fact of the matter is, Your Honor, they did speculate. At least one juror thought that ARCA was hired by Ms. Reed's car insurance or home insurance company. And think about the implications of that. If Ms. Reed's insurance company had hired ARCA, they would have had a motive to absolve Ms. Reed of responsibility. That clearly would have adversely affected their credibility in the eyes of the jury, and unfairly so.
Let me ask you a question. If I allow, and I'd be very surprised if I did, mention that this was a federal grand jury and that the federal, how does that not open the door to all the testimony that Mr. Brennan just brought up that he'd be able to get into?
Okay, so first of all, and this is later in my argument, we're not asking.
So, no, could you answer that now, and then I'll let
I'm
you say
trying to,
everything.
Your Honor.
Oh,
If-
you just
if
said
I
it's
can-
late. Hold on. You just said it's later in the
I
argument.
know, but I said you interrupted me, and I was just about to say, but I'll address it now.
Okay.
Wow. Okay. That's where and we really saw him
We are
stand
not
up for her
asking
there.
that the jury be told that there is or ever was a federal investigation. That phrase, federal investigation, never has to be part of this trial. We're only asking that they be told that the Department of Justice or the U.S. Attorney's Office hired these witnesses. That's it. We don't have to speculate about an investigation, whether there was an investigation, whether there was a federal grand jury, what that grand jury did, what that grand jury considered. Nothing. That's not what we're asking. And the problem here is that without knowing that the Department of Justice or the U.S. Attorney's Office retained ARCA, the jury's left to speculate about how they became involved, and it all inures to my client's, to prejudice my client. Thinking that they were potentially hired by an insurance company of Ms. Reed really perverts the truth in this case. It's unfair to my client, and it's the opposite of the truth. There was another juror that speculated that the ARCA witnesses were just attention seekers, looking to make a name for themselves in a high-profile case. That's also the furthest thing from the truth. They had never heard of this case before the Department of Justice called them. That's how the Department of Justice wanted it. They wanted clean experts who would take a sober and strictly scientific look at the evidence. The federal prosecutors did not want them to be tainted by news reports or opinion pieces.
Okay, can we stop it right
Nicole.
there, Michael?
Yep.
Because then that's where Brendan's going to say, well, how does Mr. Yannetti know this unless the defense team had contact with the federal government? I want to know all the contact they have because maybe they instructed them to as to what they were looking for, blah, blah, blah. Quite frankly, we don't even know what the federal government was investigating. Were they investigating a person? Were they investigating an entity? We're not quite sure, right? There could be a lot of things. You can say they investigated the Karen Reed investigation, but we don't really know who the shall we say the target is or was at that point.
This is definitely a dicey situation, and it really wasn't. I don't think it was caused by the Commonwealth. I don't think it was caused by the defense, because you just don't very often have. I've described these experts as manna from heaven, for the defense. They
Right.
just out of the blue, as a result of a totally unrelated or collaterally related investigation, their reports become available, and they are so helpful for the defense. Great, that's great. Then it's a little murky about what contact was had between the defense team and ARCA that led to their ultimate payment. And I don't think that's as crystal clear as the defense would like it to be. I say, let it all in. That's what I say. Let them have every opinion they're going to have. Tell the jury the feds hired them for an unrelated investigation, or however you want to describe that. And then let the Commonwealth say, well, these guys had this interaction with them at this date, this date, and this date. I realize it's a bit of a trial within a trial, and that can get dicey. But if the risk for the defense is we don't get all we need from the ARCA experts, I say it's a risk you got to take.
Interesting. We'll see if they do. We have some questions about this now. By the way, it also goes back to questions from this morning. Fat, Dumb, and Happy. Guys, the hearing this morning was not posted to the docket. Ooh, I didn't know that until after the hearing was over. Additionally, Karen Reed and her team were marked as not in attendance.
I think that was Brendan's wishful thinking.
Oh, very, very interesting. I just pointed out as like a little intermezzo into our roulette here on the case. Larissa Harris, Disney Nerd 85. Hank is one spinning everything. Loved AJ rebuttal and having a defense is Karen's right. Come on, Hank, put some Canton's finest on the stand to speak about the investigation protocol.
Do it.
Do it. Let's do it. Okay. And Toy says, or Twa, you say Twa, I say Toy. You have to tell us, Toy, who's right. The DNA was a hair. 5 doors of the vehicle were open at the time. Rear hatch had already been opened, and all 4 doors. I don't trust the hair didn't fly out of the Lexus, walked out, and land on the back. We don't know where that.
Yeah, I highlighted a few of these hair questions.
Hair issues,
because, that is something the prosecution really relies upon. That little hair
Right.
that's kind
That
of
little
halfway
hair,
up the
right.
rear of the right side of the car.
Okay.
Had that stay on there through all of the back and forth, and from Dighton, right? That's the
Yeah.
name.
Yeah.
Pick
Yeah.
up there, take to the Sally Port. I mean, there's a blizzard that night. I mean, I guess it's possible. I don't
Yeah.
know.
Well,
That
I don't know. Did also somebody go to the emergency room, see Mr. O'Keefe,
oh, there
and then
were
come
some folks
back to the
there.
Sally Port? Okay.
There
The
were some
hair and
folks
touch
there.
DNA being on the car means nothing to me, as they were together and she was staying with him as her house.
Yeah,
Absolutely. I
that's
mean,
another.
absolutely.
It could
Another
just
thing.
you're in and out of a hatchback, right, all the
Right.
time, and that's would not be a big
Another,
deal for a hair
another
to.
thing.
Boop.
Yeah.
It
All
just to
right.
me staying on there is the weird thing.
So we have some more. We have some more roulette. We have some more. This
Oh,
was a
you want to
point,
do some more roulette? I wish I could get to the do it part, but I didn't get
the
around
do
to
it. Oh yeah,
logging
the
that.
do it part. And
I just
and what are we talking about? We're talking about Hank Brennan saying, "Well, then we're going to have to call. We're going to have to call a witness to rebut the defense doctor, right?"
Yeah, it was about the very last witness on their list, which is Dr. No, Garrett Wing. Garrett Wing.
Garrett Wing, right?
He's the guy that is supposed to testify that the investigation was crap. And so Brennan gets up there and says, "Well, Your Honor, well, then what? We're going to call somebody to say it was perfect? That's what we have
No,
to do?"
yeah, no. That Wing is a dog expert. It was somebody else. It was Easter. It was Mr.
Oh, was it
Easter.
Easter? Oh, yeah,
Yeah,
Easter's
it's
the accident guy. You're right. I
Easter
stand
accident
corrected.
guy, and it's done all the time in cases about whether the investigation is perfect. There's expert witnesses about what should have been
Of
done, what
course.
should have been not done, and then he said, "Well, I have to call somebody else to rebut it, to say the event," and that's when do it. Just do it.
Yeah.
Okay. I mean, it
I'm-
should be a commercial.
I'm trying to get to it. Let's see if I can find that.
Okay.
Corroboration or no documents, no writings, no recordings, no videos, no audios, nothing but their word. And to allow a witness to walk in and to say negative things about Miss Reed with no way of verifying those statements is highly prejudicial. It's not just prejudicial, it's far more prejudicial than it would ever be probative in this circumstance. Even if the evidence was that he had discussed breaking up with other people,
Oh,
there are
okay.
two
I
major
remember what this is
impediments
now.
to
This
the
is not
Commonwealth's
it.
request.
This is not it, right?
No.
First, there is no evidence that, for instance, from the niece, I don't believe that there will be evidence, that was imparted, or those specific conversations were imparted to Miss Reed. The state of the facts
This is
very
because
clearly
it's
show
very
the opposite.
clear that
If we look at the
prosecution
circumstantial
wants
evidence,
to
the
argue
videos
murder
of Miss
by
Reed
arguing
at both
That they were fighting and
they
that
were fighting and there was
yeah.
animosity. She decided to with all these people around, just decide to kill him that night with the car and then drive off.
Well, she was mad. Linda, she was so mad that's what she did. I mean, that's the argument. I'm going to zoom ahead here because I really want to find. I know it's
Just do it.
I want to find the just do it, and that would have been later. Let's see, because it was toward the end, as I recall.
Let me tell you, Nettie had a game face on today that I don't think we've ever seen before.
Oh, I think that was
He
it.
had
He had a game face, Unetti?
He had a different face, a totally different face than we've seen before. I mean, it was, why he gets all his not guilty. He's a really good attorney and all. But today, normally he's smiling, he's nice and all. But today, that all disappeared. This is war.
I can tell the court, just to kind of streamline things.
Sorry, I'm looking for that moment, and it's a little
Defense has
dicey.
an intention of offering what would otherwise be prior bad act evidence, but they think it meets an exception under the rule, and then they should propose that evidence so we have time to consider it.
Especially if you intend to open on it. Are you doing the opening, Ms. Giannetti?
I will not be doing the opening this time, and I do
Okay.
not believe we will be opening on that at all.
All right.
Yeah. Who did he look at when he was asking?
So what
that?
I'll do
He
is
looked- he
not
looked
during
at-
the
he kinda
opening and
looked
only
at
with
the
advance
left.
notice and a ruling.
What would the advance notice be, Your Honor?
A week before a week before the evidence starts.
Thank you.
Okay, I'm going to do it again. I'm going to look It was such a great moment. I wish I'd
It
had time to
really
actually
was.
time code it.
Yeah, it was such a great moment, and maybe by
Maybe it's
tomorrow night.
here. Maybe it's here.
Maybe by tomorrow
We
night,
heard
we can
from the
time
testimony
code
of Jen McCabe that when she gave directions to John O'Keefe, she mentioned a mother of a child who Mr. O'Keefe had a
Oh.
prior relationship with. This is
This
minutes.
This is all about the
Before we
statements
allege the
that,
collision
about
happened.
them fighting and not getting
And
along.
so, in the interviews that she has provided
But
to
you know,
these
but while we're
different
looking
outlets,
for this, I mean, we
she
can time code it, and then
discusses
when we run our
the
best
fact that
moments
she
of
hears
this,
this information
because
and
today
that there was an
they
issue
defense have been
some type of
the
interaction
liar
about the
enough.
fact that
They've
he
been
was
attacked enough. Every
previously
time
dated
Hank
another
Brennan
woman.
turned
And
around,
this is
he
a
kind of
conversation
did a
that takes
dig to
place
them.
minutes
And I think
minutes
that
before the
today
collision.
was a turning point in how people were being treated, how people were being viewed. I just think that at this point, defense, that's it. We're you know, we ain't taking this shit anymore. You know. It just ain't happening. It's one thing to be defending your case, and you know, a lot of times when you're trying a case, you get along with the prosecutor. Believe it or not, it looks like war in the courtroom, but you have moments. You're talking about your kids. You're showing people on your phone. You know, there's moments. There's going to be none of that here. I can tell you that.
Yeah, I think the battle lines have been drawn. It's become, this time, it's personal.
So it's personal.
I was looking for Ms. Little because that was the last thing that was discussed after the do it moment. They went to, that's when she was talking about a jury questionnaire for just the media publicity element. And
Right.
the court said, yeah, that's fine. Let's do that. I know that was the last thing. And so I'm assuming the moment we're looking for, the do it moment, I think was just before that.
587, Mr. Clerk.
Thank you.
Commonwealth's motion for an offer of proof regarding calling District Attorney Morrissey and
that's
victim
not it.
witness advocate Steve Nelson.
I'm looking at my
That's
notes
not
to
it.
see
They
where
agree
that
with
came.
It also includes
Yeah.
a
That wasn't it. It's all
No,
the way
it's
to the
definitely
request
not.
to
end.
exempt from
But I'm gonna see where it is in time.
It's
sequestration.
all the way to the end.
Your Honor, with regard to this motion, we have no, on principle, we have no objection to an offer of proof as necessitated by the court's guidance.
Yep.
The issues do go strictly to trial strategy and attorney work product, so any such offer of proof, we would ask that we make that ex parte. I can tell the court, just to kind of streamline things, we would not be seeking
after this.
either of these individuals in our case in chief. They would be merely impeachment if necessary.
Okay.
Certainly, we could make those offers.
Yeah, according to my notes, it's after that.
Thank you.
Let's see.
Oh, Mrs. Katz says around 5:46 on
It
the
will
time.
take you to address that.
546?
Right?
Yeah.
So
5:46 on the time.
Okay. I believe it.
Someone says 5:53-ish, but you know, right? If someone says 5:42, but around there.
Okay, there it is. It's right there. So let's do the setup, which is, what are we going to do? We're going to bring in somebody to tell them it was perfect?
Summarize arguments. This really, from my perspective, is the role of the defense attorney to cross-examine the witnesses, to point out the inadequacies, to introduce any documents they have if they want to try to impeach the witnesses, and then the witness would have the opportunity to respond or explain or admit any type failures. This is an attempt to bolster a potential Bowden defense and a third-party culprit defense. It would involve having Mr. Easter come into court and give his own personal opinions about who a target was or who a third-party culprit may be. That would be totally improper opinion and inadmissible. They would want Mr. Easter to come in and to go through protocol of the state and local police and point out what he thinks is failures. So essentially, he's a witness that would come in, promote the defense theories, tout reasonable doubt, and suggest why somebody else committed the crime. I've done quite a bit of research. This is not a summary witness. This is not a witness that has any relevance other than his own personal opinion. This former FBI agent was a full-time member of the CAS department since 2013. He is not in a position to determine the best practices of local or state. If there are different rules and regulations that the defense will attempt to introduce, that will be a separate grounds of whether they're admissible and whether they can confront the witness. And a witness always has a right to explain or challenge accusations against them. And so I see that this witness is really simply a summary witness for the defense, but not summarizing information that the jury can then digest like information in data records or phone records, rather a summary witness of a witness who wants to come in and give their personal opinions about this case. I don't see any grounds for admissibility for Mr. Easter to come into this case and give his opinions regarding whether he thinks the police investigation was appropriate or not, or whether he would have directed somebody to do something different, and inevitably whether he thinks somebody is a suspect that was not pursued. That is all in the province of the defense in their case and in their cross-examination. So I don't see any relevance whatsoever of Mr. Easter.
All right, who's arguing for the defendant? So I need you to start by telling me what you expect him to testify to.
I can certainly tell the court that we do not expect to seek testimony or elicit testimony from Mr. Easter as to a third-party culprit.
All right, but who is he? He's a retired FBI agent?
Correct.
So what purpose are you calling him for? What's his testimony on?
To opine on the adequacy of the investigation. He is an expert as it pertains to investigations, investigative protocols, the adequacy of a proper investigation, what investigations should look like, what a proper investigation should look like.
How is he an expert on that? How is that a field, and how is he an
I've
expert
never
on it?
heard
Is it something he's done? Has he
prosecutors
testified on
being
that
asked
in
these
other courts?
questions.
He's testified in
he's
dozens
asking
and dozens, if
the
not
defense.
hundreds of courts on issues related to investigations. He was a lead case agent for the FBI for many, many years. He taught issues concerning, or taught issues specific to proper investigations and investigative techniques.
So do you have a report and CV and all that material
Yes.
that you can share with me?
Sure. I've already shared it with the Commonwealth, but I'm happy to share it with the court as well. If I think I can address many of the court's concerns as it pertains to his expertise and why the law in the Commonwealth allows, in 702, allows him, someone with his credentials, to testify to a very specific issue, like, for instance, something beyond the normal capacity of a layperson or a lay juror, and that is proper investigative techniques. A lay juror might not know, for instance, that collecting items in solo cups or grocery bags would be improper. Mike Easter certainly would know that and could opine on whether or not that followed standard protocols. What he's not going to do to assuage the Commonwealth's concerns, he's not going to or we're not going to seek to elicit testimony from Mr. Easter concerning a third-party culprit or who that third-party culprit was, but merely what investigators should do when they walk up to a crime scene and how those crime scenes should be dealt with, etc.
So is the basis of his testimony just crime scene, like collection of evidence, or is it
Witness
when
interviews.
somebody tells you somebody may have done it, you're supposed to go follow all those leads? Which is it?
That too. Both. Because if someone tells you as an investigator someone else may have done it, you're supposed to follow that lead. That is a proper investigative technique. Of course it is. But it also includes, as the court just noted, things like cordoning off the crime scene, maintaining proper logs, evidence recovery, evidence photographing, logging materials that are moved from the crime scene over to the crime lab, how that's supposed to be done, what types of logs are kept and why those logs are kept, how you bag evidence, how you secure evidence, how you maintain the integrity of evidence, and things of that nature. There is certainly, I would indicate to the court that 702 in Massachusetts mirrors very specifically 702 in the federal courts. It's literally, I looked at them side by side, they're nearly word for word. And the advisory committee notes for Federal Rules of Evidence 702 is very, very instructive on this particular issue, specifically as it pertains to somebody with the expertise in a field like crime scene investigations and investigative protocols. And what the advisory committee notes say is, quote, 702, the rule is broadly phrased. The fields of knowledge which may be drawn upon are not merely limited to, quote, scientific and, quote, technical, the scientific and the technical, but extend to all specialized knowledge. Similarly, the expert is viewed not in a narrow sense, but as a person qualified by knowledge, skill, experience, training, or education. Thus, within the scope of the rule are not only experts in the strictest sense of the word, for example, physicians, physicists, and architects, but also the large group, sometimes called skilled witnesses, such as bankers and landowners, testifying to land values. Now, again, obviously, we're not dealing with a banker or landowner, but the advisory notes and the advisory committee on the Rules of Evidence 702, the Federal Rules of Evidence 702, clearly lay out this is exactly the type of field that is subject to expert opinion. Clearly, the Rule 702 allows for experts with specialized experience, specialized knowledge, specialized education, beyond that of an average layperson, in particular, in a field without, or in a particular field, without resort to, for instance, the generalized scientific methodology that we've heard so much about in some of these motions in limine. I can go through some of his credentials, but Mr. Easter is eminently qualified to provide the jury information about proper and accepted investigative techniques and protocols. As the court noted, or as I just noted to the court, he was an FBI special agent for more than 20 years. He formally coordinated with multi-agency investigative gang task forces in Los Angeles. He worked with multiple agencies responding to dozens of crime scenes, including shootings, stabbings, abductions, child abductions, both domestically and internationally. He was the lead case agent who oversaw arrests and indictments. He received awards and recognitions for his work with the FBI, as well as with state agencies in which he was a task force member. For 11 years, he primarily assisted homicide detectives from LAPD, the Los Angeles Sheriff's Department, and the Los Angeles District Attorney, numerous other agencies as well, state and local agencies, with investigations and prosecution of thousands and thousands of homicides, robberies, kidnappings, other violent crimes. His work and assistance on investigations in LA and across the United States and ultimately internationally has been noted by not only the FBI, but those agencies as well. Just a few of Mr. Easter's experiences and involvements in some of the domestic and international cases include the 2015 San Bernardino mass shooting.
So are these all on his CV that you're going to give me a copy of?
Everything, I believe, all.
So I don't need you time again of the restraint. If you're going to give me a copy of the CV, I can read it. You don't need to recite it.
It's either, what I was reciting is either in the CV or in his report.
Okay, so that's what I need. That would be much more helpful to me.
Why don't you just tell her it's the Crosby rule?
I don't know what more the court
Just
would
apply
like.
the
So I
Crosby
wanted to know
rule.
specifically what you intend to have him testify on. But if it's in his report,
It's in his, it broadly is in his report. I don't know exactly every question I'm going to ask him, but I can tell the court in broad brushstrokes, obviously, we're going to ask him, we've already asked him to review, he's reviewed NOD 1 through 59. We're going to give him the additional NODs that we've got as well. He's going to review everything. And from that, he's going to, I expect, render an opinion about whether or not the investigation followed standards and training, best case practices for an investigative
so I guess that's my
technique.
question. So without seeing the report, where are their standards and best practices? Is that something that somebody can turn to and see codification of it, or is
So-
it just his experience?
No, it's not just his experience. Those standards and practices are oftentimes reduced to writing. They have been reduced to writing with the Massachusetts State Police. So he's reviewed the protocols that are in place for the MSP.
Okay.
He's very familiar with FBI's protocols for investigative techniques and investigative protocols. He'll utilize those skills and that knowledge base to assess his opinion, or to render an opinion and a conclusion concerning what he believes are the proper protocols that should have been followed in this case. That goes directly to our Bowdoin defense, and he is the primary expert that we would use to propound that Bowdoin defense.
All right, can you get me that report before you leave? Do you have it extra?
I think,
All right.
I think we probably have an extra copy of it, yes.
Mr. Brennan, did you want to respond?
Here comes foot in mouth Brennan.
Mr. Easter was a agent who did CAST. He did the CLSI. He may have been in hundreds of cases. I'd like to know what cases he's come into court and given his subjective opinion about how he feels an investigation was done. Not a report, not an assignment, but as an expert witness in Bowdoin. How many cases has he gone into court and testified and been allowed to testify about his personal opinion? His experience in the FBI is different than Canton Police Department and the state police.
I hope so.
This is just Monday morning quarterbacking, and it's an attempt to bolster argument by counsel so that they can use some type of opinion to lean on when they're arguing to the jury. They should have doubt because of the police investigation. I don't see any recognition under 702 or in law where somebody can come in and subjectively give their opinions. If there is a state police protocol that wasn't followed, then the defense can see if that state police protocol is appropriate. If they're speaking to a state police officer, question them about it and ask them if they did it and why. If this person comes in and gives opinions, there'll be a slew of opinions that are shot like a shotgun approach that we'll never be able to have an opportunity to explain. Are we going to call in the Canton Police Department again and call in the state police for a second round so they can explain why they chose certain actions that Mr. Easter is criticizing? I don't think this is an appropriate ground for an expert witness. I don't see any cases, I've looked through the state and federal court, that allow an expert to come in on a Bowden defense and give their subjective opinion about an investigation they weren't involved with. I don't know that this witness has ever been qualified as a Bowden-type witness in any court. He may have testified, but about what? And so I think this is a very dangerous proposition. What if the Commonwealth wants to counter and bring in a state police officer to say that the investigation was fantastic, that everybody did a remarkable job under the circumstances? What if we bring in a witness to talk about the fact that the evidence is so overwhelming that it should imply a certain finding by the jury? This invites that. This invites a debate between people's personal opinions. That's done outside of the courtroom, not in a courtroom. We will never have an opportunity to be able to have all the witnesses come back to explain what this witness subjectively thinks was a deficiency.
Ask them in the beginning.
It's appropriate for expert witness testimony. This is argument by counsel.
Look at, he's ready to get out of his chair. Alan's like, let's do it.
I gently disagree with Mr. Brennan. He indicates that we want to use an expert to bolster our argument. There's another word for that, or another phrase for that. It's called presenting a defense for someone charged with murder. He indicates, well, what are we going to do? This guy's going to get up there and testify. What am I supposed to do? Call a bunch of other Canton PD officers to talk about how great their investigative techniques were? Yeah, there's another word for that. It's called rebuttal. That's what you're supposed to do. And then he says, well,
You wouldn't be objecting if they called somebody in rebuttal to reinforce a great investigation?
Oh, no. Mr. Brennan said, what if I called in a Massachusetts state police officer to say that this was the best investigation ever? I have two words. Do it.
Do it.
Do it. I'd love that. I'd love a shot at that.
Okay, so I said let's take personal.
That's not an invective. That's not a personal
Right,
shot.
yelling at him, that's a
I'm saying
personal
do it.
shot.
You want to call in another expert? That's a classic battle of the experts. That's fine. I'll put Mike Easter up against any expert they want to call. But the reality is, Your Honor, we're entitled to present a defense. And part of that defense, the Bowden defense, is the adequacy of the investigation. And there's no question that a proper homicide investigation is not something within...
I don't know. So if you can give me a case site for that.
Oh, my God.
All right? That expert testimony regarding a Bowden defense, I've never seen it. I've never seen it in research or anything. So I'd like a case site.
There are certainly cases outside the jurisdiction.
Yep, Massachusetts case. If not, you can give me the outside cases, but I don't believe there's a Massachusetts case.
Should have denied them having somebody having an expert
for
witness.
a specific case in Massachusetts.
Because Massachusetts hasn't reached that issue yet?
There isn't one directly on point, but there are plenty, there's a myriad cases outside the jurisdiction where investigators are called consistently, especially on behalf of the defense, to talk about adequacy of an investigation.
All the
That is an
time, all the
expert
time.
field, one that's utilized throughout
So
the country
I
all
need
the
some
time.
authority, and the more persuasive the authority, the better chance you have at this. Okay?
Sure.
So she's already I can't take any more of her. She's already prejudging what she's going to do. Her advisory opinion is basically, I'm not going to allow him to testify unless you can come up with something to convince me otherwise.
Unless you give me a Massachusetts case, which may not have reached the issue because maybe they didn't have such good lawyering. Maybe there wasn't an issue to be reached. Maybe no one.
Well,
had the
maybe
funds.
because it's such an obvious decision. Remember, these things don't happen unless they go up on appeal, right? But it's such an obvious decision, a no-brainer, Judge Bev, that it's never been discussed before on a Massachusetts appellate level because no trial court is so stupid that they wouldn't let it happen, that this witness would not be allowed to testify.
Right. Unbelievable, unbelievable to me. Unbelievable to me. I have a lot of questions about this. John Courtney. And by the way, she then castigated Alan Jackson for I told you to keep this at a professional level. Oh, he did. He didn't.
All he
He
said was,
didn't.
"Do it. Bring on this
What are you
witness."
doing? He didn't castigate Hank Brennan. Hank Brennan attacked the defense team all day today,
She's
all day. And
she's
that's what
so
turned me on Hank Brennan
sensitive.
today, because I was really supporting him. You know, on the show, I've been supporting him, being a good attorney, being a good attorney. But I was really annoyed the way he went after people today with that little dig every time that he had to answer something. You know,
Yes, in
come on.
his little nasally weird voice.
Yeah.
And she's
Solo
just so
cups.
hypersensitive to the Commonwealth being accused of something, chastised, embarrassed, that she takes anything said and construes it as a dig against them. That just reveals her bias.
It's just ridiculous. John Courtney's Solo Cup Stop and Shop metadata chain of custody reports. Yeah,
Yeah.
the red Solo Cup. It's taught by
That is a
crime scene
perfectly
all
acceptable
the time.
method of collecting evidence.
Evidence.
It's in a book somewhere I read.
I
Yeah.
can't wait. How about the evidence on that Oasis cat? I wish Hank would have put Chloe on the list. She's who we want to. Yeah, put Chloe on the list. Bring Chloe in.
Poor Chloe.
Let's
Chloe's
bring
taking
Chloe in without
bad
a
rap.
mouthpiece, without a muzzle too. Let's bring Chloe in without a muzzle.
Here's
you know?
we jumped one another again. I'm getting
I'm
this one back
sorry.
here. I'm going to take up drinking after today, says Lisa Small. All I can say is, God bless you for waiting this long.
Oasis can't follow up. I would like to do a lineup of everyone in that house and unleash Chloe. Yeah, bad people to live with. I mean, poor Chloe's being defamed, right? Poor Chloe's being defamed. Prince
Chloe's
Lover,
got,
Linda clutched her pearl.
TMJ.
I'm not wearing pearls today, but I'm gonna clutch my necklace.
Yeah.
I mean, why is it that the defense? The question, what got me is that you have that guy with the dogs, right? Nothing.
Crosby?
He's nothing.
Which guy?
Yeah.
Oh, yeah,
Crosby,
Crosby's
right?
good. He's in. He's good.
Nothing. Just all these people, nothing. The defense wants to put on an expert who's apparently got great credentials, who's testified in the past, and
he's testifying as to the efficiency and proper nature of the investigation. It's such a common subject to have an expert testify about.
Right.
It's common. Now, in this case, it's needed more than others, perhaps, but it's common, and she's just trying to protect them from exposing what the investigation was really like, which most people could tell was horrible. Right.
Right. I mean, the answer would have been, the real answer would have been, Mr. Jackson, the investigation was so horrible, you don't need an expert to assist the jury, right? That's the real answer, right? If you want to say it, but you can't say it. But I tell you what, this is what's driving people crazy. This is a case that seems so easy, right? And then you have all this stuff, and then you come into court, and but I think what's happening here, viewers got attuned to the judge in the ASAP Rocky case being fair to the defense. And we talked about it. Well, maybe there's a defense shift here with Paige Whitney and there's not guilty verdicts. They got used to some of these judges being fair. And then we come in and we see this is how the defense is usually treated. I'm telling you, everybody, the defense is, you have to go above and beyond. And you get a question in every situation, and your experts get attacked, and they're just being paid. When the Commonwealth people that come in, they have pensions, they get salaries, they have friends. It's constant. I mean, you're seeing it right here. And the problem is you're seeing it from somebody who used to be a defense attorney for 26 years, who is respected among the judges, is probably going to go to the Supreme Judicial Court and be a justice there at some point. So, but this Easter thing was to me unbelievable.
Yeah, and we'll see. She's certainly suggesting, denied. Not So Goodland has given a case site that I'll have to follow up on, but suggests, I guess, that case site stands for the proposition that somebody like Easter can testify in a Bowdoin context, which is the efficiency of a police investigation context. I'm going to look that up, 464 Mass 580. So should pass that along to the defense, but they do have people.
Well, so. I mean, the real objection would have been if you were Hank Brennan. Hey, the FBI doesn't do murder investigations very often, right? They don't do homicide investigations very often. That's the real attack on Easter. Okay?
Yeah, unless they're mass serial killers or something that crosses state lines.
Yeah, But you saw the Nettie today with the, I was about to get that when you interrupted me, and
I
I was
know.
about to tell you I'm going to answer it. So the
Yeah.
defense was feeling, defense was feeling the no love in court, and they weren't taking it today.
Yep. So I think
Yeah.
that's the perfect way to wrap this up. That was so classic. Brennan stepped in dog poop, and Jackson pushed him down and rubbed his nose in it. I like that.
Yeah. And and you got the poor Aiden's case today about no taint. We don't know, who the taint team is. We don't know who the cert. Remember, we didn't know who the cert team was. The taint team. The JSC, they will always acknowledge good lawyers, including the prosecution or any opposing party. Yes, to make an account. We tell you, we try to call it as we see it,
Yeah,
right?
I got nothing against Judge Bev if she'd ever do something more appropriate, but I'm going to call out when she does something inappropriate.
Yes, but something happened. I don't think that it was this way in the first trial as we're seeing in this case. Something happened with that with the ACA experts, and that's where we are.
Yes, that was the the grave concerns. Okay, so
okay, so we ended up going 2 hours instead of the hour we said we were going to go, because all of you were here, all of you were staying with us, all of you had such great questions. But I think tomorrow. There's no court. We're actually going to do, I think, a premiere tomorrow at 5 o'clock, right? And then we tell people we're going to premiere an episode with the great attorney who Michael Bryant has named Fonnie Willis's worst nightmare. That's Ashley Merchant will be giving us another exclusive interview. All right. And we are going to run it as a premiere. We will be, or at least I will be interacting with you on your chat at 5 p.m. tomorrow. And the reason why we're running it at 5 instead of 6 is because we do expect that some of these orders will come down, and that we expect that at 6 o'clock tomorrow, we'll probably be having a show.
We'll see. We'll see how that goes. Who knows with Judge Bev? Who knows? I may be with Lisa Small drinking. So I don't, who knows? Who knows what's going to happen?
Somebody accused me of sounding like I was drunk again. And as you all know, I seldom drink. I may have a champagne here or there, or a female cosmopolitan with this much liquor. Actually, I don't even put liquor into it.
You have the Virgin Cosmo?
Water. Yeah, Virgin. When I ask for Virgin Cosmo, people laugh at me. They think, well, who gets a Virgin Cosmo? But yeah, I do get excited sometimes, and also Michael's been told he has to slow on his scroll. I've been told I have to slow on my speech. We get so excited. Yeah, well, we have to fit it all in within time. So we've been on the air for, I think, about 8 or 9 hours today. Again, Michael Bryant.
So I think I'm going to get out of here. In the meantime, we'll see you tomorrow doing something, somehow. Ashley Merchant is going to be very exciting. Find out what's going on with Fonnie. She owes a lot of money. In the meantime, try to do the right thing. We'll see you then.
And I'm Linda Kenny Bodden. Please, before we go, just take a moment, hit that like button right now. I'm looking right now. I'm looking at the like button. Come on, you can hit more. Come on, hit that like button. I see you all. Yeah, a lot of you there. Okay. Subscribe, share, and we'll see you tomorrow.